Mr. Runke, Mr. Herman. Do you wish to make an opening, or Mr. Beecher? Good afternoon, ladies and gentlemen. You may have forgotten who I am. It's been a while. My name is Robert Beecher, and I am one of the attorneys for Aaron Granton, who you now know is also known as eBay. And Mr. Herman and Ms. Panetti are my esteemed colleagues. And of course, we have Mr. Runke and Jean Barrett also at the defense table. It's always easier to go last because so much of what I was going to remind you of has already been said by, I'd like to call Mr. Runke Professor Runke. He is a very knowledgeable attorney. And so some of what I was going to say, I'm not going to belabor the point, it's already been said to you. But like anybody who else addresses individuals in a public forum like this, I am no different than any of you. I get nervous. I've been doing this a long time. I still get nervous. And I can guarantee you that when I sit down, there are things that I wanted to remind you of, that I will have forgotten to remind you of. And I'll kick myself under that table. And I'll hope that you, when you eventually deliberate in this case, well, you know, Mr. Beecher didn't talk about that in his opening. But you are free to talk about it, and I hope you do. During your deliberations. Now, I do want to start out right away by acknowledging kind of the elephant in the room here, which is the tragedy of Mr. Johann Kamitz's unfortunate passing. As you already know, there may have been a misimpression by the way that he was gunned down, and I'm sure that that was not purposeful, but that was at the very beginning of the government's opening statement remarks. As you now know, he was essentially run over by an automobile driven by Mr. Ivory Davis, and he was killed. There is nobody in this courtroom who is familiar with that, and you are now familiar with it, who does not acknowledge the tragic circumstances of his passing. And you should know that we all feel the same way. But that is not the point of this trial. The point of this trial is, how did we get to that place? And is Mr. Granton responsible for bringing us there? Or is Mr. Hardy? I represent Mr. Granton. In any kind of a criminal case, your job is to find the facts. Now, Judge Block has already gone over this at some length with you, but ultimately, you are the arbiters of what is believable and what is incredible, not believable. As Mr. Runke has so correctly pointed out, we have witnesses in this case who are essentially singing the same sheet of music. They are all individuals with lengthy criminal histories. They all have motives provided to them after their arrest by the government to come before you and testify. And I'm not insinuating by the way that the government is asking them to lie. That is something they will do on their own. These are honorable attorneys. They are colleagues of ours. We're all lawyers in the system. When you see us greet each other, we just happen to be on different sides. But these are honorable people, and they can't pick their witnesses. They can't go into a Boy Scout camp and pick out their witness. That's not the way it works. Regrettably, however, you are going to listen to people who have what a professor of mine used to call in law school a motive to falsify. And I loved Professor Cyrus. He was wonderful, and that phrase has stuck with me for over 40 years. A motive to falsify. And you will learn that these gentlemen who will be testifying, these government cooperators, Troob, Taz, the crew, them ample motives to testify. They will have a muscular, literally a muscular and brutal dedication to bending and folding and mutilating spindling the truth for their own personal gain. They did it in their daily lives when they were on the street, and they are doing it now. Some of them are incarcerated so that they do not have to be in custody very much longer. That is an important incentive to come before you, the finders of the fact, and say things which are not necessarily so. And speaking about things which are not necessarily so, I don't know how many of you folks are familiar with the wonderful Gershwin operetta, Porgy and Bess. You don't have to raise your hand. But there is a wonderful song, and it was called It Ain't Necessarily So. And the lyrics went something like this. I promise I'm not going to sing it. It ain't necessarily so. The things that you're liable to read in the Bible, it ain't necessarily so. Well, this is the perfect forum for that maxim. It isn't necessarily so, and you will find out soon enough why. You will find out, as Mr. Runke so correctly pointed out, that a number of the witnesses who will come before you even during their cooperation decided that it was in their best interest to commit further criminal offenses. And you'll be sitting here. What is this? They agreed to come in and tell the truth, and yet they are out there on the street committing other crimes. How can we believe anything that they say? Anything? There's a principle in Latin known as falsus in uno. Lie about one thing, lie about everything. And we suggest that they are lying about just about everything. A number of you, when you were voir dired by Judge Block, you talked about your hobbies, and many of you go to the movies. And I'm sure most of you are familiar with the term a film noir, N-O-I-R. Well, this is going to be a film noir in Technicolor though. And it's going to highlight mendacity, lying in high definition. Most of us have high definition televisions. Now that's what you are going to get in here. You are going to get a high definition example of prevarication, lying. It's in their interest to do so. They also have an interest, as the government will suggest, and properly so, to tell you the truth, because if they don't tell the truth, they are not going to get their 5K letter, right? I mean, that has been part of the preview here. However, who is going to say whether they are telling the truth? That's up to you, and we suggest that they are not telling the truth. And why do we suggest that? Because there is going to be evidence that they are not. What kind of evidence? For example, timelines. Timelines are going to be very, very important in this case. We have no obligation to say anything to you. I don't have to give an opening statement. As you know, Mr. Granton, eBay, he doesn't have to say a word. He can sit there and twiddle his thumbs for the next 5 weeks. It doesn't matter, but I am going to make a promise to you, however, and that promise that if you pay close attention, you will see that the times of certain events will become critical, and I would love to tell you why now, but I just cannot do that. I'm going to ask you to pay close attention because, after all, that is your job as jurors. Your job is to use a wonderful philosophy that came from the great University of Wisconsin, of which I am a very proud alum. And that is that the continual fearless sifting and winnowing by which the truth is to be found is to ask questions. That is how we get knowledge, the continuous fearless sifting and winnowing. And that's what we are asking you to do in this trial. You will have to sift and winnow a lot, and it's not going to be very pleasant sometimes. But at the end of the day, We urge you to conclude that the evidence presented to you is simply not sufficient to render a guilty verdict, that it raises more questions than there are answers, and if there are more questions than answers, that is reasonable doubt, and if you have a reasonable doubt, more questions than answers. Your verdict must be, as Judge Block will tell you, not guilty. Now, I'm pretty much finished, because Mr. Runke was kind enough to say many of the things I was going to say, and we are not going to repeat them for you. But you also must pay close attention to the fact that on your oaths and in your questionnaires, you were reminded repeatedly that we have absolutely no obligation to put anything before you. As I said a few moments ago, I don't have to give this opening statement. I have no burden. That is the government's burden. The defendants, my client, Aaron Granton, does not have to testify. And sometimes that is a very, very difficult concept for people to wrap their heads around. And why is that? Because all of us remember when we were in middle school or high school, wherever we were in school, and if we were sitting in the back of the classroom and there was noise and the teacher said, "Well, I'm Mr. Beecher, okay? Mr. Beecher or Robert, you'll have to go to the principal's office. I don't like the fact that you were talking." If I wasn't talking, what would my reaction be? To raise my hand and say, "But teacher, it wasn't me." Well, let's fast forward. Here we are in the United States District Court for the Eastern District of New York, and Mr. Granton is accused of very serious crimes. But guess what? He doesn't have to raise his hand and say anything. Even if you want him to say something, you must instantly disabuse yourself of the notion that you have that eager desire to hear from any defendant at any time ever. It doesn't have to happen. And that's because in our constitutional system, nobody is required who is charged with a criminal offense to say anything at all. Now, that is not always so easy to do sometimes, but you really have to do it. Now, you are probably wondering, and this will be my last remark to you because you have to be wondering, eBay. Where did eBay come from? Because Mr. Granton is known as eBay, you're going to hear a lot of testimony about eBay, eBay this, eBay that. Well, he certainly didn't get it from the website eBay, but when he was a little boy, and there actually will be testimony about this, when he was a little boy, probably about the age of 4 or 5, the name eBay came from a Jamaican song. And somehow, some way it got attached to Aaron Granton, and that's where we get the name eBay from. Because you must have been wondering a few minutes ago, eBay, what? Where is that coming from? Now, not a big deal, but at least now, So you are starting off the trial with an absolute certainty. That's where he got the name from. A Jamaican song when he was a little boy. I appreciate your patience on behalf of Mr. Granton. Either Mr. Herman or I will be before you again at the end of the proceedings, at the end of the evidence to address you once more. I ask you to keep in mind what Mr. Runke and I have reminded you of in terms of your obligations, and what we believe will be your perception of the evidence. And at the end of the day, you will render a verdict of not guilty. Thank you so much for your time. Thank you, Mr. Beecher. So we're going to take a break until 4 o'clock if you want to use the facilities.